Talked to her this morning. She said she was going to be here. All right. She said she was on her way. All right. Want me to get this here? The Honorable Coach Burns presiding.
Morning, everyone.
Morning, Ron.
All right. All right, is Ms. Kohlberg, did you say she's gonna be on the Zoom link? Okay, give me 1 second. There we go. All right, we'll call Michelle Coleman versus Charles Coleman, 22-3-1207. Do we have Ms. Kohlberg's on the Zoom link? Do we have Ms. Costello?
No, Your Honor, Ms. Costello is not going to be on this morning. Your Honor, parties requested a special set and we did speak to your clerk, Your Honor, and it seems like I'm sorry, I heard someone else speak. It seems like the March 29th special setting date, if we could set a date that would
Absolutely.
work for both parties.
Ms. Kroll is on the Zoom link.
Oh, okay. She's fine.
Kroll, what were you thinking on the 29th? Are you all going to planning on Zooming in or coming to Dayton?
I plan to be in person, Your Honor.
Ms. Kroll,
We have that time open, so I was curious what time would work for the parties.
What were you thinking, Ms. Kohlberg, or do you have times for Ms. Costello as well?
I am available all day, and Ms. Costello made it seem like she was available all day as well.
You want to do
How long?
9:30? Oh, sorry, Ms. Kroll, go ahead.
I guess that was going to be my next question that we weren't able to clarify in email was how long were you going to need for this hearing?
I think this will take at least a good 30 minutes.
So we can set this for 9:30 then. Does that work for you, Your Honor?
Yes, I was thinking that way I could come over and be in person as well. That leaves the afternoon open if anybody needs it in either of the 3 counties, or any of the 3 counties, I should say. All right, will you let Ms. Costello know that we will be having the hearing on March 29th at 9:30?
Yes,
Perfect, thank you. Ms.
thank you, Your
Colbert.
Honor.
All right, that'll conclude the Coleman matter for today. And next we'll call Christie's Realty versus Caitlin Hussey, 23-2507. We have Mr. Ortuno present in court for the plaintiffs. We have Ms. Hussey present. And do we have Mr. Shatlow? Oh, Miss Shatlow. Okay, how did you say your first name? Dilovan. Cool name. All right, that's 23-2507. I will tell you all that I reviewed the file and I didn't have anything from defense counsel. And then I heard, was this the case, Madam Clerk? That it was, they were waiting for FedEx or something and it didn't make it or something like
That's
that?
the next case.
Oh, okay.
Yeah, so we resolved this matter, so we actually have an
Cool.
agreement to present to your honor. It's a CR2A order agreement of move out with a payment provision. Ms. Schlato wrote it. I reviewed it. Her client has signed it. My client has signed it. We were ready to present it to the court.
Wonderful, perfect, thank you. All right, I've signed that order.
And then, Your Honor, the only other thing I would ask is maybe it would make sense just for scheduling to put this over to the first April court date, just in case.
There's any issue?
Right, and that way we don't have to try and specially set something with you or chase you down.
Absolutely, right, I know, my calendar's awful. What about April the 5th?
Yep, that's great.
And if you don't need it, you can strike it.
I
if
will
you-
strike it if it's all
Okay.
done by April 1st.
Perfect.
I will appear April 5th. I hope we don't need to appear,
Okay.
but I will be here the week after.
Well, we don't have court until the end of April, so why don't we,
Oh, I see.
So it's either April, my calendar looks all goofy. Yeah, it's the 5th or the 19th.
Let's leave it with the 5th. I try to call in if I have to.
okay,
I
hopefully
hope I don't have to.
we don't need it.
Perfect. All right, thank you
Your
all.
Honor.
Thank you. All right, the next matter I have is Dayton Eagles Homes versus Deanna Chorley, 23-2407. Sorry about that. So that was the one, because I got online yesterday on Odyssey and I saw there was an objection filed by Mr. Ortuno, but I couldn't see it. I couldn't like open it. And so I emailed Madam Clerk and she emailed it to me. And then she indicated this morning that there was supposedly filings made by defense counsel, but they still have not made it. Oh, they did. Well, no, this is your objection.
I do have my answer, motion to dismiss physically here. I did not file it downstairs yet because I wanted your honor, in case you want to glance over it. I made it before.
Did you get an opportunity to review it?
I did.
Okay.
We tried to overnight it on Tuesday, on Monday, I apologize. I have the FedEx receipt in the office. I'm not quite sure why it didn't make its way over to your honor. I talked right up to but, at the same time, I sent it over to plaintiff counsel to review. So I believe you had an opportunity.
So if you guys want to make argument, you can, if you're both prepared, and I'll just take it under advisement so I can actually read what was filed. That's very important. The only other option I can think is to get a special set or continue it, and I'm sure plaintiff's counsel doesn't want to do that. So if you're fine with it, just, you can make argument. I'll take it under advisement, enter a written decision.
I'm fine with that.
Okay.
That's
All right, Mr. Ortuno.
Good morning, Your Honor. We're here on an unlawful detainer pursuant to RCW 5918-650, subsection 2B, which allows a landlord to evict a tenant upon 10 days' notice for substantial material lease violations. The 10-day notice was served with identifying 6 individual lease violations on January 17th. Complaint was filed along with all the other documents on February 7th. This court signed the OSC on February 7th. The defendant was served with those papers on February 10th. All notices of service, declarations of service are on file with the court. This hearing was continued from February 22nd. We'd argue, Your Honor, on the order for a writ, there's no triable issue of fact with regard to the lease violations. It was a written lease for 1 year for the tenant to stay there as an accommodation after her husband passed away. The tenant is 59 years old. The facility is for people who are 62 and over. The lease says that on page 1. It's been known since the beginning it was going to be a 1-year lease. There are several other lease violations articulated within the order and the moving papers, including allowing another person to stay in the facility with the tenant. That person has been harassing and intimidating neighbors. We've had neighbors move out. There's been smoking. The tenant has not allowed the landlord to inspect the facility for safety precautions. So there's ample evidence, overwhelming evidence actually suggesting that it's proper to issue a writ now. To address, I'll address the defendant's motion. There was a motion to dismiss. I got it Monday afternoon. It's lengthy. So I went through it as best I could to try to get something to the court in opposition. But defendant makes 2 principal arguments. One is that the plaintiff did not comply with the CARES Act in providing a 30-day notice to vacate. And they cite a Washington authority for that. And that the backup argument is that the 10-day notice was not sufficiently, did not have enough detail, not enough specificity. As to the first argument, Your Honor, it seems to be that the part of the brief that has to do with the CARES Act is somewhat canned. It doesn't really apply to this situation. So the CARES Act, in the actual language of the USC 9058, which I quote in my opposition, applies to cases that for failure to pay rent. The entire eviction moratorium set forth by the CDC dealt with people who could not pay rent because of the economic impacts of the pandemic. Washington had the same provisions. Nothing in the CARES Act, nothing under Washington law prevents or requires 30 days extra notice or the application of the CARES Act for eviction reasons beyond failure to pay rent. In this case, it's a lease violation. There's ample evidence, which given the time frame between when I got the motion to dismiss and today, I was not able to cite for the court, but there's guidance from HUD online, Consumer Financial Protection Bureau, which all make clear that if you can't pay your rent, you're entitled to these benefits. You're not entitled to those benefits when you're violating your lease or committing some other sort of violation that leads to an eviction. So the CARES Act simply does not apply. I would also note that even if there's some ambiguity with that, as of November 1st of 2022, the defendant was no longer receiving subsidized housing benefits. So that's over. So there's no subsidized housing, so the CARES Act wouldn't apply anyway. There's a sentence or two that I saw in the motion indicating that 60 days notice were required prior to the end of the lease because the lease expired in October, but those aren't the moving grounds either. The moving grounds are that she's in violation of the lease, not that the lease ended. So the 10-day notice under RCW 5918-650 2B is appropriate. And lastly, with regard to the argument about specificity, we actually added 6 lines in there indicating what the specific violations of the lease are. The lease is attached, for your honor, to the complaint. Each one of those violations correspond to an express provision of the lease with regard to the age of 62 requirement, with regard to not disturbing other residents. You're the only person allowed in the facility. Those are all well set forth. So the argument for that the notice lacks specificity fails. that was a mouthful, so I'll sit and allow, I'm sure defensive counsel is going to want to address that, but in sum, we believe it's appropriate for the court to issue issue the order for execution of a writ upon this motion.
All right, thank you, Mr. Ortuno.
Thank you.
All right, Ms. Shatlo.
Yes.
Okay, make sure I say it right. Go ahead.
Thank you, Your Honor. In sum, yes, Mr. Ortuno has summarized my motion. So I'm moving to dismiss the case on two different grounds, either or the CARES Act, so non-compliance with the CARES Act notice, 30-day notice to cure, along with the 10-day notice to quit or vacate. My second basis to move to dismiss is lack of specificity in the 10-day notice. In the alternative, if Your Honor does not acknowledge that these two violations are grounds for dismissal, I am asking that Your Honor recognizes that we are speaking about questions of fact that have to be determined in a trial or a special setting and cannot be decided upon in a summary proceeding, such as the unlawful detainer. To speak about the CARES Act notice, my argument is that if a quit or vacate notice is submitted by a housing provider that has availed itself to federal subsidies, that housing provider has to comply with the CARES Act and submit a 30-day notice to give the tenant time to acknowledge that there were lease violations, and if there were lease violations, 30 days to cure those. The CARES Act notice is in compliance with the 120-day moratorium that was imposed upon the states when COVID first started, but it is the 120-day moratorium was never limited to only non-payments. In the case that I cited that was decided by the court in December, the Sherwood-Auburn versus Pinson case, the case dealt with a 14-day notice where the court found that with a 14-day notice, a 30-day CARES Act notice has to be attached in order to be able to be successful in an unlawful detainer action. However, the court did not specify that it's limited to 14-day notices. In fact, the court said that any housing provider availing itself to federal subsidies should in turn let the lessors know through a 30-day notice. It was never limited, and so my argument hinges on, even though we were talking about the 14-day notice in Pinson, it has never been limited to only 14-day notices when there's an unlawful detainer. So just based on the failure to submit a 30-day notice, Your Honor should dismiss the case because the notice is not, does not meet the statutory notice requirement and therefore is deficient. With a deficient notice, there should not be an unlawful detainer. The case should be dismissed and plaintiffs should resubmit a 30-day notice and give my client the time to cure the purported lease violations. The argument that my client does not receive subsidies anymore, that her housing was terminated in November, is irrelevant because first, we do not know if there are any other tenants in the premises who may or may not receive federal subsidies, and it's not limited on one tenant receiving that. So it's not tenant-based, it's building-based. So if there's anyone else in the building that receives those subsidies, the landlord still has to submit a 30-day notice. And second, my client has received subsidies until a termination letter was sent out in November. The letter itself that Mr. Ortuno attached to the objection to my motion does not, it says specifically that this notice does not terminate, she's still eligible, she has to respond. There was not a final termination letter attached. It was a notice that her subsidies may be terminated. So my argument is the federal subsidies are tied to the building, not the tenant, and therefore the 30-day CARES Act notice should still be required. Second, the notice does lack specificity. Mr. Ortuño said he submitted 6 lines on the notice stating these violations. However, statutory requirement, and I have briefed that in my answer, statutory requirement is that the burden is on the plaintiff to prove with a preponderance of the evidence every allegation made in the notice. And the notice has to be so specific that the tenant can identify the specific lease violation with certainty to form a defense. And this was not given here in the notice. The notice says an unauthorized guest was harassing neighbors. It doesn't say which neighbors. It doesn't identify who the guest is, what the guest allegedly did, how often the guest was observed in the unit, how often any alleged behavior occurred. We don't even know what the guest did to intimidate or harass neighbors. We don't know, Mr. Ortuño said, neighbors said to move out. We don't have any evidence in the file, either explaining the situation, shedding light on what it is. It leaves the tenant to guess who came, what took place. There's no way that she can remedy a situation if there is one, if we don't know what happened, who did it. You know, there's no identification, male, female, young, old, nothing. We don't know what happened. So there's lack of specificity with this argument. Again, it says, my client smoked in the unit. There's no observation. When did she smoke? Who knew that she's smoking? Why did they see smoke come out the window? Did they smell it? There's no description. It's just one allegation. And there's no evidence, no specificity. Further, it says, and I don't have the notice in front of me, but I'm trying to remember. Further, it says, she has an unauthorized guest residing with her. Again, how do we know who the person is? How do we know this person is residing there? No statements given. We observed the person coming in the evening, going in the morning, leaving. We don't know, did the person park the vehicle? How was it identified that there is a person and that this person is residing there? No specificity. We cannot address this. So my point is, any of the claims made by plaintiffs have a lack in specificity as to the point that it leaves the defendant guessing what the violation is and how to cure it. The final point is, it is the age limit. So the property is a facility that only houses tenants that are over the age of 62 years old. My tenant lived in her unit since 2015, right? Since 2015, and we have submitted the declaration of my client, sworn under penalty of perjury, where she gives her narrative. So my client and her husband moved in 2015. At the time, they were not 62 years old, but at the time, the requirement was that a resident either be 62 years of age or be on disability. They applied. Dayton Eagle Manor board discussed their application and approved them to be residents. So they lived there until in October of 2021, my client's husband passed away. In the same month, October 2021, Dayton Eagle Manor entered into a direct lease agreement with my tenant, who at the time was not 62 years of age. At some point during their residency, so between 2015 and 2021, management of Dayton Eagle Manor changed and they imposed this age limit on their residents. When my client or her husband asked management, well, we are not 62 years old, what happens to us? Dayton Eagle Manor said, you are grandfathered into the lease. You've been residing here. We're not going to kick you out. So with that premise, in October of 2021, my client entered into a lease agreement with Dayton Eagle Manor. Dayton Eagle Manor, knowing my client does not meet the age requirement. However, they entered into a 1-year lease agreement. So the mere fact that they're now pointing out that my client does not meet the age requirement is somewhat outlandish, because they have known all along that she does not meet the age requirement. I would argue waiver of that requirement when they entered into the lease. They were completely informed. They have known her for almost 6 years at the time, 8 years at the time. So it's not, this argument just leaves us surprised. And there's no way that she can cure it in 10 days. She's not going to turn 62 in 10 days. Even if she wanted to cure it, it's not, that's out of her control. So, Your Honor, I will rest my case at this. If you do not find that there are grounds to dismiss this case for lack of CARES Act notice violation or for lack of specificity, I urge you to understand, to acknowledge that there are questions of fact in this case to each one of the purported lease violations, and that this case should be special set or set for trial so that we can find the facts. Thank you, Your Honor.
All right, thank you. All right, Mr. Ortuno, response or reply.
Yes, Your Honor, and I will try to keep it somewhat brief. So I know you haven't had a chance to review the papers yet. So with regard to the imposed age limit, from what I heard and what I saw in the motion to dismiss, there's an acknowledgement that the defendant knew at the time she signed the lease that the policy was you had to be 62 years and over. I think this case falls under the category of no good deed goes unpunished. They didn't want to kick her out of a facility after her husband died. They wanted to give her a year to be able to get her life together and figure out something else that would work for her. However, if we want to be lawyers about this, the lease is a contract between the plaintiff and the defendant. It has plain language that says you must be over 62 years old. There's no contractual waiver saying that my client somehow waived their right to enforce that 62-year-old requirement. It's a one-year lease. From what I also have heard, there was an acknowledgement that she wasn't 62 at the time and that this was a one-year lease. Presumably she signed knowingly. Therefore, even if we were having a case about breach of contract, there couldn't be parole evidence to try to have an interpretation of the contract that goes against its express language. Which brings me to my next point, the whole 62 years old, the specificity argument. Counsel for the defendant went through all except for the age requirement. The age requirement alone is enough to grant the order to show cause and to execute a writ. Again, she knew at the time she was 59, and so did my clients, or 58, I guess, at the time. They're trying to do something nice for her at a tough time. And so it was a one-year lease, knowing full well that at the end of that year, they were going to enforce the 62-year requirement. And again, that is enough in and of itself, by the plain language of the lease, to enforce the unlawful detainer and the order for a writ based on the statute upon which we're moving, which is the 2B subsection of 59-18-650. Lastly, with regard to the CARES Act, defense counsel acknowledged that the only Washington case applying the CARES Act was a 14-day pay or vacate, but you have to read a statute. It's common statutory interpretation. You need to read a statute as a whole. And if you look at the language which I cited in my opposition to their motion to dismiss from USC 15 USC 9058, you scroll down to B, 2B. No, it's just B, sorry. It talks about, it's the moratorium section during the 120-day period beginning on, which then got extended. The lessor of a covered dwelling may not make or cause to be made any filing with the court of jurisdiction to initiate a legal action to recover possession of the covered dwelling from the tenant for non-payment of rent and other fees or charges. It says nothing about violations of lease. And again, if the judge is, if your honor is inclined to, or needs more briefing on that, there's ample online landlord and tenant resources from HUD and the Consumer Financial Protection Bureau. They all speak of, if you can't pay your rent because of the pandemic or economic consequences, you have rights. Doesn't say you can go ahead and freely violate your lease or commit any other malfeasance and you're going to get protection. It's never been extended. It certainly isn't in the Washington authority. of Sherwood Auburn versus Pinzon. Defense counsel hasn't provided any other authority to the contrary. In sum, Your Honor, I understand the court is going to take this under submission. I do have a draft of an order for the writ. If I could hand that up, so it's part of the
Absolutely.
file. I appreciate it. And if there's anything else you'd like me to address, I'm happy to.
I don't think so. All right, I'll put this with Madam Clerk. I'm just gonna hook this to the file so that it's part of it. Do you have any proposed order you wanted to hand up to make part of the file?
Your Honor, I think I printed one, but I have to find it. But may I address Mr. Ortunio's? I don't have it.
You guys have cross motion, so if you want one, you need to say something, you can go ahead.
Thank you, Your Honor. Very briefly, I understand the argument that there was a one-year lease agreement. However, under the Landlord-Tenant Act, the lease agreement, even though on it as a termination date, if there's no 60-day notice to terminate the lease will automatically convert to a 100 month. So that argument doesn't go very far to say her lease agreement was only 1 year if it was not. And to the CARES Act, yes, Pinzon, Sherwood Auburn versus Pinzon addresses 14-day notice. However, the court also says that Washington abhors evictions basically, and any statute should be construed in favor of the tenant. With that, Your Honor, I hope you do not grant this unlawful action. Thank you.
All right, anything further from either side?
Briefly.
Yeah.
What's a landlord supposed to do? If the Dayton Eagles Homes is a nonprofit that runs low-cost housing for seniors that are over 62 years old. We chose a statute that fits the situation within the context of the Landlord-Tenant Act that allows the landlord to evict a tenant for lease violations. Can't evict a tenant for lease violations, and we can't evict her for failure to pay rent. If you have a tenant who's blatantly violating the laws for whatever reason, how does a landlord ever assert their rights? I think that's a conundrum now that we're faced with. And again, I think that the legislature, both Congress and Washington courts so far have limited this CARES Act provision and limited the imposition of federal law so that landlords still have some rights to control their own property. Thank you.
All right, thank you all. All right, I will take it under advisement. I did put your answer and motion to dismiss in the file so the clerk can file it and then give the file back to me so I can read everything. And then I have your order hooked to the front of the file. Did you say you did have an order you wanted to hand up that was proposed?
I know I printed it, but I cannot find it.
Oh, okay, if you find it, you could just send it to Madam Clerk.
Thank you.
And then Deputy, do you want to give Ms. Shatlow this email address for the future? That's my court administrator, so that if you're worried about FedEx reaching, I know Mr. Ortuno knows this, people can always send bench copies to her and she just forwards it to me.
I didn't know about the whole FedEx fiasco. I would have told you.
Oh, that's okay. I know FedEx just assumes to do it, but
Yeah.
it's been interesting. All right. I will take it under advisement and thank you both for your